Welcome to Channel AMEC, your insight to the Australian visa system. Good day everyone, my name is Carl Young, your online YouTube visa consultant. Are you interested about my go to Australia? Why don't you consider to subscribe to my channel and turn on a little bell on the side, so once we have all the updates and news, you'll be the first one of getting all the insight. Now today, this video, I would like to take you into a little bit of depth of the student guardian visa. And obviously there are a lot of parents who wishes to accompany their child to Australia to study. Now that's not a problem, but if you do have another child who is the age probably younger than your first child, obviously you will be, can they actually come together? Can they, or can he or she can come together? Now obviously there's a complication for welfare taken care by a parent. Now obviously a parent will always say, yeah, of course I'll take care of my child and all my children's, but there are certain laws and rules required and policy required to go through. So some people actually get visa rejected on their student guardian visa because of their wanting to taking another student guardian dependent child. Now let's get into the law and explain further. So we're looking at the legend come again. I've always referred to this digital library, which we could access all the detail there. We are looking into depths of the subclass 590 student guardian visa. Now it's pretty simple as long as there is obviously your child is studying in Australia under the age of 18 and can accompanied by a parent or grandparent as a guardian to have that visa. Now obviously this visa does not allow you to work. Your sole job is to taking care of the child. So anyway, we are talking about a part which is rarely explained or discussed in detail in the secondary criteria, which by means it's the visa applicant who are dependent on the student guardian visa. So student guardian obviously will be the parents or the grandparents. Now if they want to take another dependent child, probably on the age younger, perhaps 6 or less, let's have a look at the 590.312. It says here the applicant must not have turned 6. Now what does that mean? Now so 6 years of age is very important because once you turn 6, it's compulsory by law in Australia to be educated. It's the right of a child. Now it has to get them into a school. So obviously if the child is over 6, now obviously they don't qualify as a dependent, because he or she will require to go enroll into school and he or she will apply her own student visa subclass 500. So what if it's going to be under 6? Now it doesn't say that under 6 you will automatically get it. It only says the applicant must not have turned 6, but there are certain conditions which a lot of people probably will not be able to access to. Let's jump into the actual detailed policy here. Now I'm referring to the 590 of student guardian dependent children under 6. As you can see here, I have that highlighted under 4.5.2 family composition. Now this part is actually very important. Now a lot of there are some forum and website does have a little bit of explanation, but today I'm going to take you a little bit of detail in here. So let's read this. Student guardian visa applicant who have family unit member under 6 years old cannot satisfy 590.213. What's that one? 213 is obviously going up here. Is if any family member has not turned 6, the applicant has established compelling and compassionate reason for the grant of visa, or the applicant satisfy requirement of 590.2114. 2114 is, let's go up there. See applicant meet if obviously it's been nominated or else. Okay, so if we're going down here, this is the key here. Now what does compelling and compassionate reason actually defined. Let's go into the policy here. So it is bilateral benefit case, refer to bilateral benefit case, student guardian eligibility, or the applicant demonstrate compelling compassionate reason for grant of visa. So what are these? Officer may accept compassionate compelling reason exists if the primary student guardian, who is going to be the parents or grandparents, applicant usually provides support of nominating student in relation to medical condition. Okay, so what does that mean? So obviously, if you're the mother of your child, if your child gets sick, obviously the mother or the father will take care of the child. So that's what it meant. Now, if you were a grandparent, a grandfather, now if the child got sick, usually it's the parent taking care of their medical thing, right? Medical condition. So that will not meet that requirement. Okay, so that's first most important things. And is the sole parent or custodian of the nominating student, and is also required to care in Australia for their children under 6 years old. Okay, so obviously the only person here, generally 99% of the chance, will be the parents, not grandparents. Officer may carefully consider under GTE, that's the general temporary entrant criteria provision, to the intention of the parent who plan to leave a child under 6 years old in home country and accompany older sibling to Australia. Officer should satisfy that the appropriate welfare arrangement in place of the other child in the home country refer to the welfare arrangement, which is down here, but that's something out of Australian immigration officers' control. So officer may also see evidence of comparing reasons in inform custody of a document alternative, welfare arrangement, medical certificate letter from a medical practitioner. Now, here it doesn't say much. Now, what does that actually mean? Now, giving you an example, the other younger child under age of 6 will require to demonstrate that if he or she is not accompanied with a parent to Australia with another child, the older child, there's no one taking care of them. Okay, or he or she. Okay, and obviously, if he or she got any medical condition, for example, getting sick, no one's taking care of it. So you need to demonstrate that in order to pass this criteria, in order to pass 590.213. Again, let's read again. The applicant established compelling compassionate reason for the grant of the visa if they haven't turned 6. So how do we deal with this? Generally is we would not advise the student visa application straight away accompanied with the 590 straight away and with the dependent, because if one failed, everything failed. Okay, so we should aim at getting the student, the actual primary student visa granted, then we deal with the student guardian visa, then we deal with the dependent child later on. Otherwise, if one fail, you got no guardian, and the student visa obviously will be rejected. So it's actually a very complicated part of law. If the younger child can be welfare can be taken care of by another parent at their home country, that will be the best solution. But taking a younger child together might jeopardize the whole application. Anyway, it's really going into everybody's private circumstances. Everybody have different background. You may have some queries. More than welcome to leave a comment right down below, and I see you next video. Goodbye.